All right, let's dive right into this explainer and explore the really fascinating intersection of artificial intelligence and legal strategy. We are looking at a wild new frontier in law right now. On one hand, AI is completely democratizing legal knowledge. But on the other hand, it's opening up these massive vulnerabilities that could expose your deepest, most private legal strategies directly to opposing counsel. So today, we're going to forge a modern suite of digital armor. Think of it as a conceptual work product vault, using both legal doctrines and technical shields to protect your personal brain. Listen to this stark warning from Sam Altman, the CEO of OpenAI. Unlike a therapist or lawyer, ChatGPT doesn't come with confidentiality protections. I mean, when the creator of the most popular AI tool in the world tells you flat out there is no confidentiality, we've really got to listen. People so often treat these chatbots like a confidant, a therapist, or even a lawyer. But without those built-in legal protections, literally everything you type into that prompt box could potentially be weaponized and used against you in court. To navigate all this, here is our roadmap for today. First, we'll look at the AI legal boom. Second, we'll uncover the confidentiality trap. Third, we'll forge our work product shield. Fourth, we'll discuss justice for pro-se litigants. And finally, we'll build the ultimate digital vault. Okay, Section 1, the AI legal boom. We are currently witnessing a massive surge in AI adoption across the entire legal landscape, and it is fundamentally changing how legal work is done. It's honestly not an exaggeration to say this is the biggest shift in legal practice since court records went digital. Small law firms and self-represented litigants, who are also known as pro se litigants, are leveraging AI for incredibly tedious but super essential tasks. We're talking about spinning up initial document outlines, summarizing those endlessly dense public court opinions, and drafting routine, non-confidential communications. For someone who can't afford a lawyer, an AI can seem like an absolute miracle worker, suddenly making the complex world of law feel completely accessible.
But that brings us to Section 2, the confidentiality trap.
Here is the terrifying problem. The very tool people are bringing inside their castle walls to defend themselves might actually be a Trojan horse. It really all boils down to this one crucial question. Does attorney-client privilege actually apply to AI? Just imagine you're in a high-stakes civil dispute, and you innocently ask ChatGPT, hey, what happens if I accidentally breached this specific part of my contract? Could the opposing side literally subpoena those logs and read your exact thoughts? Well, according to recent research from Duke Law, the answer is a hard no. Traditional attorney-client privilege fails entirely here. See, privilege relies on a human relationship and a fiduciary duty of confidentiality. Because you're talking to a machine, an entity with absolutely zero ethical obligations to you, your strategy is completely exposed to discovery. If you are asked under oath in a deposition whether you consulted an AI about the lawsuit and you say yes, opposing counsel could send a document production request for those exact chats, leaving your defenses totally breached. Which leads us to Section 3, the work product shield. Since traditional privilege fails to protect our perimeter, we've got to look to a different kind of armor to fortify our position. Enter the Work-Product Doctrine, specifically Federal Rule of Civil Procedure 26b-3. Think of this doctrine as a legally sanctioned safe room. It protects any documents prepared in anticipation of litigation from discovery. It's exactly what allows a lawyer to brainstorm, make mistakes, and prepare for trials safely, without the other side just peeking at their notes. But here is the modern twist. How exactly does the shield apply when the person doing the preparing isn't actually a lawyer and their assistant is an AI? Now, this highlights a glaring and honestly pretty dangerous gap in the law. When we compare protections side by side, a lawyer's mental impressions, which is known as opinion work product, get absolute ironclad protection. But for everyday people representing themselves, the rules are highly contested and totally ambiguous. Fact work product, like say a simple timeline of events, gets some baseline protection for everyone. But if a self-represented litigant uses AI to brainstorm legal theories, courts are completely split on whether that internal thought process is safe. It's a massive crack in the armor for the very people who need protection the most. So how do we address this? That is Section 4, Justice for Pro Se. There is actually some real hope here, as we saw in the recent 2024 Warner v. Gilberco case. In this case, an opposing party literally tried to compel a self-represented plaintiff to hand over their AI drafting process. No way, right? Well, a federal judge in Michigan ruled that this was an improper intrusion into the plaintiff's mental impressions. The court treated the generative AI not as a third-party human that breaks confidentiality, but as a private drafting tool, protecting the plaintiff's internal analysis as opinion work product.
This is a huge, game-changing precedent for protecting your personal brain when using these modern tools.
Researchers at Duke Law frame this struggle brilliantly through what's called the Rawlsian veil of ignorance. Imagine society is rewriting the rules of court from scratch, but you have no idea if you'll be rich enough to afford a high-powered lawyer or if you'll be forced to represent yourself. What rules would you want? You'd naturally argue that a person shouldn't be penalized with lesser confidentiality simply because they had to use a digital tool to understand their basic rights. It's a fundamental issue of social equity and fairness, plain and simple.
All right, moving on to Section 5, the digital vault.
So we've explored the legal armor. Now let's look at the technical shield that guarantees this privacy through the software itself. According to the Sovereign Tech Audit, we have to abandon the vulnerable, yellow-flagged open courtyard of cloud AI for sensitive legal matters. Cloud AI means data logs, public networks, and the constant looming risk of data leakage. Instead, we need to move into the green, impenetrable vault of local first AI runners like Ollama. This represents total local sovereignty. The AI runs entirely on your own computer's hardware. There are no data logs sent to corporate servers, no APIs dialing home, just 100% on-device privacy. Your legal strategy literally cannot leak to the internet because it never even touches it. And you can do some amazing things inside that vault. Researchers at Georgetown Law have actually outlined how to use these secure systems for complex agentic workflows, which basically means the AI acts as an autonomous agent doing multi-step tasks for you. By running models locally in your digital vault, you can have the AI securely gather facts, outline potential claims, analyze case law completely offline, and even draft well-structured briefs. You're essentially getting the full power of a multi-agent AI legal team, but without a single byte of your strategy ever leaving your machine.
But hey, remember, any technology is only as good as the human wielding it. Whether you're using cloud tools for basic research or local tools in your vault for deep strategy, you've got to strictly follow these practical safety rules. First, never, ever file anything in court without verifying every cited case. We've all seen those embarrassing headlines of lawyers submitting fake AI case law to very unimpressed judges. Second, never paste confidential fact into public chatbots. And finally, always treat AI output as a rough draft. It is an incredibly powerful tool for sure, but it is not a licensed human attorney.
As we wrap up this explainer, I want to leave you with this provocative thought. AI has irrevocably lowered the barrier to legal knowledge, which is an absolute win for access to justice. But as it brings this very real risk of exposing our deepest strategies, how is our justice system going to rewrite the rules to ensure fairness for everyone? Are we going to make sure that the digital vault of justice remains secure and accessible to all? Or are we going to allow a two-tiered system where only the wealthy get the privilege of privacy? It's a huge question we're all going to have to figure out as this technology keeps evolving.